Good morning and welcome to the North Carolina Court of Appeals. We have one case on for argument today, Expert Discovery LLC versus ATT Corp et al. Wanted to introduce the panel today. To my right is Judge Carpenter, to my left is Judge Wood. We'll be your panel for this morning. I want to welcome, I see a distinguished group of the bar here. It's good to see all of you. Welcome. And I want to welcome the law clerks and particularly the interns at the Court of Appeals who are here to witness this argument. It's good always to have a group of interns. I want to thank Officer Remillard and Mr. Saunders for their work today. And we will hear from the appellants.
May it please the court. Your honors, my name is Chet Rabin. I'm with the Rabin Law Firm in Mecklenburg County. I'm here this morning with my co-counsel, Robert Edmonds, Kip Nelson, seated at counsel's table, Robert Hunter and Robert McKeever. They are respectively with Fox Rothschild and Higgins Benjamin over in Greensboro. Collectively, we represent Expert Discovery in this False Claims Act case that was filed on behalf of the state of North Carolina. Now, for logistics in my argument this morning, I wanted to let you know that I'm going to present the arguments for the appellant as to the first to file bar as briefed in our papers, and Mr. Nelson will then come and present all the remaining arguments. We would like to reserve 5 minutes of our argument time for rebuttal. Your honors, the North Carolina False Claims Act was enacted in 2009 and became effective in January of 2010. The False Claims Acts, both at the federal level and the state level, are intended to incentivize relators, individual persons or corporate companies that are formed for the purpose of bringing a QTAM action, to bring forth civil actions to recover damages on behalf of the federal government or the state governments in this case, to recover for fraud caused by, fraud, waste, and abuse. And since the North Carolina's enactment of the False Claims Act that came on board in 2010, our state has recovered billions of dollars through the North Carolina False Claims Act. And in fact, most of that money has come from relator-filed cases, not by cases initiated by the state government. The False Claims Acts, both at the federal and state level, have been referred to as being the single most important tool in fighting fraud, waste, and abuse across the country. This case was filed under the North Carolina False Claims Act to recover hundreds of millions of dollars that should have been paid to the state of North Carolina for use by the 911 board, by the defendants in this case, who were charged with the duty to properly collect and remit 911 surcharges on each telephone number that was capable of accessing the 911 system. And that's the basis of our claim. The 911 system, as everybody knows, is a system that allows someone to use a telephone and dial 3 numbers, 911, and reach help, whether it's police, fire, medic, or whatever they need. And the system is vital to the citizens of this state. And it's very, very important that it be properly funded and that the funding be sufficient to have the highest level of technology as technology changes. Back in the day, we didn't have cell phones, and landlines were all we had. Now with cell phones and VoIP and other forms of telecommunications technology, it's important that the system be well funded. This case was originally filed in 2014. We filed an amendment in 2016 while the case was still under seal, and a second amended complaint in 2020. In June of 2020, after a period of investigation, the Attorney General declined to intervene at this time. And by so doing, they allowed us, the statute allows us, the relators, to pursue the claim on behalf of the citizens of North Carolina. So we proceeded to litigate. We served the defendants. The defendants responded by filing motions to dismiss. Those motions to dismiss were heard by Judge Stephen Futrell, and he granted the motion to dismiss, and that's why we're here today on appeal of that order. And I'm here, as I said, to present the arguments as to the first-to-file bar. That was one of the principal bases of his order, the first-to-file bar.
And Mr. Rayburn, am I correct that your client is an Alabama LLC and has filed numerous of these claims throughout the United States? Is that correct?
That is correct, Your Honor. Expert discovery is an entity, it's called a corporate relator, and that's not uncommon in the world of False Claims Act cases these days. And as a corporate relator, it became highly informed. The principal of expert discovery is a former telecommunications executive, and a number of cases were filed around the country in different jurisdictions, primarily state courts, and there were some that were filed in, for instance, the District of Columbia, the D.C., the city court, if you will, for the District of Columbia, to recover under each of those states' individual 911 laws. 911 laws across the country are unique to the jurisdiction in which they are passed and in which they operate. There is no federal 911 law. There's no federal 911 surcharge. And therefore, every single one of these claims had to be filed in the state that was affected by that unique statute. And they were filed, obviously, only in states that have state or city false claims acts. Let me tell you about the first-to-file bar. The first-to-file bar is in North Carolina contained in NCGS Section 1-608. And I want to show that on Elmo, if we can turn on Elmo.
I believe it's on.
Okay. Let's see. All right, so this is the version of 1-608 that was in play from 2010 until there was an amendment in 2018. And we'll talk about this in just a moment. But the defendants argued basically in the trial court that the first-to-file rule barred this action because a sister company of expert discovery, which was called Phone Recovery Services, had filed an FCA action or had filed other FCA actions, False Claims Act actions in other jurisdictions. And specifically, there were 3 cases that were filed before the North Carolina case was filed. There was a case filed in Iowa, a case filed in Chicago, and a case filed in the District of Columbia. And the main prior action that was the subject of argument below had to do with the Iowa case. And so that's one I want to talk specifically about. But keep in mind that the principles there also apply to the other 2 cases. So what Judge Futrell had to do is he had to first determine that the first-to-file rule applied, and then he had to determine that its application barred this action. And under the first-to-file rule, we have to look at the version that was in place, and I have that now down on the Elmo. And I want to draw your attention to, I want to draw your attention down here to subsection 5, which is where Judge Futrell, we say, erred in his ruling. This reads, when a person brings an action under this subsection, the Federal False Claims Act gives the site, or any similar provision of law in any other state, no person other than the state may intervene or bring a related action based on the facts underlying the pending action, provided, however, that nothing in this subdivision prohibits a person from amending a pending action in another jurisdiction to allege a claim under this subsection. Now, when we look at what the judge did in the case below, he basically determined that, well, as the defendants argued, there was another action. It mentioned 911, failure to pay 911 surcharges, and therefore this action is barred. But that logic is flawed. Your Honors, under the plain wording of 1608B, the court erred by applying the first to file bar because this action, this present action, is not a related action based on the facts underlying the pending action. And the pending action, according to this statute, would have to be the Iowa action or DC or Chicago action. And let's talk for just a second before I go back to this. What is the purpose of the first to file bar? The purpose of the first to file bar is to, one, encourage and incentivize relators to promptly report fraud. That's a race to the courthouse. If you know about fraud, you need to go do something about it to stop it as quickly as possible. And then, and what that does is it puts the state or the feds on the trail of the fraud so that they can investigate the fraud. And then secondly, it avoids parasitic action. It's parasitic actions, which is actions where other persons either they bring a later action or somehow they learn of an action and they want to jump on the wagon train. But that's not what happened here because we have the same company as the plaintiff in both cases. But again, the primary purpose of the first to file rule is to promptly inform the government of the fraud so the government can be put on the trail and start the investigation. Now, it's very, very important to look at the entire statute 1608, subsection B. Not just that last little piece, not just that subsection 5, and look at that as a balloon by itself floating in the sky. If you look at the entire section of 1608B, you start with this, and the title of this section is Civil Actions for False Claims. And this is the section that allows a private person to bring a False Claims Act case, and they are called either the relator or the qui tam plaintiff. Now, the first section says, the action shall be brought in the name of the state. So the first filed action has got to be styled something along the lines of the state of North Carolina, ex-rel, expert discovery. That's what the statute says. It's got to be in the name of the state. The second thing it says is that a copy of the complaint and written disclosure and substantially all material, evidence, and information the person possesses shall be served on the Attorney General. So you have to bring the first case in the name of the state, and you have to serve the complaint and all material, documentation, evidence that you have on the Attorney General. All that's under seal. You can't go to a public document and figure out if this case has been filed. As a qui tam lawyer, we don't know these things. We might be filing a case and another case has already been filed. We just don't know. But what this says is that the first filed case to which the first file bar might apply later on has got to be brought in the name, has got to be brought in the name of the state of North Carolina. And that's not what happened in the Iowa case. If you, judges, if you look at the Iowa complaint and the Iowa complaint and the DC complaint and the City of Chicago complaint are all in the record. You can look at them. This complaint is 22 pages and 105 paragraphs long. The words North Carolina are nowhere in this document. The plaintiff in this case, which again was a sister company, never attempted to bring a claim on behalf of the the state of North Carolina. And most importantly, they did not bring a supplemental jurisdictional claim such as, claim number 1 is on behalf of the state of Iowa, claim number 2 is on behalf of the state of North Carolina. They didn't bring a count that was laid in favor of the state of North Carolina. They did not serve the Attorney General of North Carolina. The Attorney General of North Carolina would have had no way of knowing of the existence of that case. And North Carolina was never put on the trail of fraud in that Iowa case. And that's just not how the first to file bar or the first to file rule works. Classically, the way it works is when you have a case that generally is a case filed in a federal district court, and count number 1 or 1 and 2 are federal claims. They're for the violation of the Federal False Claims Act. And then maybe counts 2 through 30 are on behalf of various states that have state false claims acts. And those claims are properly brought as supplemental claims in that case. And if a second filed relator comes in and brings a new lawsuit in the same or a different district and more or less pleads the same allegations of fraud, say it's something like off-label marketing or whatnot, then that second file case is going to be barred by the first to file rule. But importantly, if the second filed relator names a claim or presents a claim that the first filed relator did not bring, let's say the first filed relator brings claims on behalf of states 1 through 10, second filed relator brings claims for 1 through 10 plus 11 through 15, then second filed relator is barred. They are not first to file as to the claims for states 1 through 10, but they are first to file as to 11 through 15 because the first relator didn't name those states. And that's how it's intended to work. And if you consider how would that work in this case, what if there was a claim that was brought vis-a-vis telephone service, in this case, in a federal court somewhere else? It would be something like this. Here's the hypothetical. When you pay your phone bill, all of your charges are basically state-related charges. There's the phone bill for the service of the text and the data and the calls, et cetera. And then there's a series of charges and taxes and things like that. There's also one that's called the USF, and that's the Universal Service Fee. And that's the only thing that goes, that is basically legislated by Congress and would be payable to the Federal Communications Commission. That's the only potential federal money that's a part of your phone bill. So if a claim were brought and it was like the federal claim because they over-collected the USF charge, and then they also realized that there's a bunch of 911 surcharge failure to collect and remit those, and so there were 11 or 15 or 20 different state supplemental claims in that complaint. As long as they name the state of North Carolina and the North Carolina Attorney General gets served and they know about it and they're put on the trail of fraud, then if we come in later and present that same 911 case, we're barred. But that's not what happened here. And again, look at the Iowa case, look at the DC case, look at the other case, Chicago case. There is no effort and no intent to have served or to have brought a claim on behalf of North Carolina. And that's how the first to file bar is supposed to work. And judges, when you look at this case and you make your rulings on it, you've got to look at 1608 in its entire context. And you've got to understand that down here at number 5, when it talks about when a person brings an action, it's talking about the first filed action. And the first filed action that you're comparing the later filed action to, for purposes of applying or not applying the first to file bar, you've got to look at Section 1 and Section 2. Section 1 and 2 say you got to bring it in the name of the state of North Carolina and you got to serve the state of North Carolina. That did not happen. And as a consequence of that, the first to file rule or the first to file bar does not apply in this case at all. And I would lastly say this. At page 8 of our reply brief, we talk about the Taylor versus Crisp case, and it speaks to the canon of construction that says that if the interpretation of a statute, according to its literal terms, leads to an absurd consequence, then you look to the intent and purpose of the law, and the manifest purpose of the legislature, or as otherwise expressed, the reason and purpose of the law shall control. And that's what should apply here. That should apply in the complete reading of Section 1608. And the bottom line simply is this. The first to file bar just does not apply in this case to take the second file case and compare it to the first file case, because the first file case never attempted to bring a claim on behalf of the state of North Carolina. It was not brought in the name of the state of North Carolina, and the AG's office was not served and was never put on that trail of fraud. Thank you.
May it please the court, my name is Kip Nelson. I would like to address the alternative basis for dismissal based on the retroactive application of 2018 legislation. As your honors know, the 911 Act was amended and modified in 2018, and the question is, what is the effect of those amendments? There are two hurdles that the defendants have to overcome in order to apply the legislation retroactively. The first hurdle is whether the legislation looks backwards at all. The second is whether it applies to pending claims. Because neither hurdle was overcome here, the trial court erred in dismissing the complaint on this alternative basis. So turning first to the question of whether the legislation looks backwards at all, the parties agree that there is a presumption against the retroactive application of legislation. This is no trifle. Our Supreme Court has said if there's any way to read the legislation prospectively, then it has to be given that interpretation. So the question is not, can the defendants come up with an interpretation of the statute that they think favors their position? The question is, has the legislature provided express intent to apply the legislation retroactively? And of course, the General Assembly knows how to do that and does so with some frequency, whether it's using the word retroactive or tying the legislation to some date or milestone prior to the enactment. In fact, in the very same bill that the defendants are relying on here, the legislature did that and made certain provisions retroactive. But when it comes to the amendments to the 911 Act, the legislature did not make it retroactive, did not say anything about looking prior to the effective date of the legislation. The trial court appeared to overlook this presumption and therefore erred in its interpretation of applying legislation retroactively. Even if the legislation could be applied retroactively, then the defendants face the second hurdle, which is, does the legislation apply to pending claims? And on this point, our Supreme Court has been very clear. If the legislation does not make any allusion to pending claims, then courts will not read that provision into it. This rule is straightforward and clear and in place for good reason. The ability of the legislature to interfere with ongoing judicial proceedings is carefully circumscribed for a reason. There are certain circumstances in which the legislature can affect pending litigation, but our Supreme Court has said if you're going to do that, you have to make your intention very clear. That's highlighted in the cases cited in the briefs, for example, in Dyer, where the legislature explicitly addressed a pending lawsuit. That was the purpose of the legislation, to say there is a lawsuit pending against these commissioners, and we are enacting this to relieve them of liability. That was clear, that was explicit. On the other hand, a couple of years later, the Supreme Court addressed the Lexington grocery case, where the legislature repealed a law, and then there was a question of what effect that had on penalties. And the Supreme Court said, when there's no reference to pending litigation, the court can't read that provision into the legislation. So turning to this case, the 2018 legislation has no reference to pending litigation. There's no indication that a suit was pending. There's no reference to this case or any other litigation. Without an explicit reference to pending claims, the trial court erred in reading that provision into the 2018 legislation. And again, the General Assembly knows how to do that and has for some time. So on occasion, it has said this legislation will apply to claims pending on or after the effective date. In fact, in the 1800s, our Supreme Court said that's the language our legislature always uses, if that is the intent. But again, none of that language can be found in the 2018 modification to the 911 Act. The reason these hurdles are in place is also to preserve the integrity of the separation of powers. So obviously we have 3 branches of government and each has its own role. And there are constitutional concerns that arise if the legislature is intending to affect the other branches. Expert discovery, as the appellant has raised 2 of those concerns here, both affecting vested rights and impairment of contract. To be clear, this court does not need to rule that the 2018 legislation is unconstitutional. That's not what we're asking. The question is how the 2018 legislation should be interpreted. Our point is that interpreting it in the way that the defendants have suggested would create constitutional concerns. And when our Supreme Court, like in the Bank of Pinehurst case, has been faced with that situation, It has provided another reason to apply the presumption against retroactive application. So here, because the 2018 legislation does not on its face apply retroactively and does not on its face apply to pending claims, and because applying the legislation retroactively would create constitutional concerns, it should be applied prospective only, and the trial court erred in interpreting it to the contrary. For those reasons, we would ask that this court reverse. And unless the court has questions, I'd like to reserve the remaining time for rebuttal.
Mr. Nelson, your Discovery Experts is a Alabama-based limited liability company. As best I can tell from the record, there's no other connection to the state of North Carolina. Is that fair?
Other than what's been alleged, as far as the entity itself?
Other than this lawsuit, that's the only connection that entity has with this state. Is that correct?
I believe that's correct.
1-608 references an action by a private person, references a person, the person. On 4 or 5 different occasions, does a Alabama limited liability company with no other relationship with this state qualify as a person under that statute?
Yes, and there's no limitation in the statute to defining a person. So presumably a general statute of limitations, for example, that says a person cannot bring a claim more than 3 years, that would apply to someone who was injured in North Carolina regardless of whether he or she was a North Carolina resident. The same thing here. The legislature did not limit the universe of potential relators to a corporate entity formed in North Carolina. So yes, to answer your question, a person is broadly defined to include expert discovery here. All right, thank you.
We'll hear from the appellee.
Thank you, Your Honors. May it please the Court, my name is Scott Angstreich from the Kellogg Hansen firm. I'm counsel for AT&T. With me at counsel table is Jim Phillips of the Brooks Pierce firm, counsel for Charter, and we collectively presenting argument, or I'm presenting argument on behalf of all the defendants here. The 911 law funds the 911 call answering centers by imposing a tax on telephone customers. Telephone companies like my client and the other defendants are made the middleman in that scheme. We are directed to put the tax on the bill that's sent to our customers pay the money, and then we turn the money over to the state. There is no allegation here that any telephone company put a 911 charge on a customer's bill, got the money from the customer, and then put that money in its pockets. The allegation is instead that the customers should have been paying, the business customers in particular, should have been paying more taxes in the past than they were charged, and that the telephone companies, when they turned over the money they actually billed and actually collected to the state, violated the False Claims Act by somehow saying something false. Exactly what is not clear. The trial court correctly dismissed that. And I'm going to start where Mr. Nelson started with the 2018 law. Because in the 2018 law, the legislature says unambiguously that no telephone company and no telephone customer shall be liable for billing or paying too few 911 charges, whether under the currently codified law or its predecessors as previously codified. And there are 3 ways in which that language, and it's at page 102 of Expert Discovery's appendix at the bottom, there are 3 ways in which that language unambiguously shows retroactive intent. First, it talks both about a bill that is rendered, that is something that's going to happen after the effective date, and a bill that has been rendered. Bills that have been rendered necessarily happened in the past. There's no reason to add has been if you're only talking about things yet to come. The statute also says that it applies to bills that are rendered at any time prior to 180 days following the effective date, not just during the period of 180 days following the effective date. So at any time is incredibly broad language. And it was added to the bill after the budget bill was enacted over the governor's veto. It was added in a corrections bill that corrected lots of provisions in that budget bill. But the third, I think, is the clearest of them all, because it says that it applies to bills that are rendered whether under section 143B 1403 or its predecessors as previously codified. 143B, 10403 is where the 911 law is today. And it was put there in 2015. Prior to that, it was in section 62A-43. So any bill that was rendered under its predecessors as previously codified had been sent to customers at least 3 years before this provision took effect, and in the years previous to that. There is absolutely no reason for the General Assembly to refer to bills sent under the predecessors to the 911 law in its prior codification in section 62A-43 if the legislature did not mean to immunize customers and companies for having gotten 911 charges wrong in the past. Expert discovery says nothing about any of this language. You didn't hear Mr. Nelson talk about it at all. This is not a case where one could come up with creative interpretations to read those phrases as only referring to the future. And expert discovery is wrong in suggesting that you need magic words. This is retroactive. This applies to the past in order for something to be retroactive. The Springer-Eubank case from this court that we cite, the Estridge case from this court that expert discovery cite, they both make clear that retroactivity, I'm quoting here, can be clearly expressed or arise by necessary implication from the terms of the statute. And in Springer-Eubank, this court concluded that the legislature's decision to use the word hold, because it was a past tense word, had the retroactive effect of approving an electric cooperative's obtaining of an interest in a propane gas business at a time when the statute hadn't actually let them do that. The legislature's decision to use the word hold meant that they were retroactively sanctioning that and allowing it. Here we have far more language. We have has been, the past tense, just like hold, at any time, and under its predecessors as previously codified.
Counsel, what case law would you rely on that would qualify to show that the legislature intended for this legislation to apply to a pending case?
Absolutely, Your Honor. And there I think we have a category error from expert discovery, because the cases that talk about requiring special language applying to pending cases are cases that involve repeals. Nothing was repealed in 2018. The legislature didn't repeal the 911 law. It didn't repeal the False Claims Act. What it did was, as it did in Dyer, it did a remission of a penalty. And Lexington Grocery, in fact, distinguishes those two. It says, and this is at page, I don't have the page number here, but in the same paragraph that expert discovery is citing, it says, where the right has been asserted during the life of the statute, as for instance an action instituted to recover a penalty, the plaintiff acquires an inchoate right subject to be defeated by express legislative action. No mention about special language about pending actions. But where the statute is simply repealed and no allusion is made to pending action, well, then the inchoate rights continue. So if this were a repeal, if the legislature in 2018 had simply rewritten the 911 law from scratch and said, as it did in Lexington Grocery, that all laws in conflict herewith are hereby repealed, yes, I agree. They would then need to say, and this applies to pending actions. The new statute applies to pending actions. Actions brought under the old statute are no good anymore. But where, as in Dyer, all you have is the absolute and express remission of a penalty, there is no case that says you need extra language that says, and this applies to pending actions. It applies retroactively because that's the purpose of a release. And that's what this is. This is the government's claim, right? The government is the one that is owed the money under the 911 charges. The claim here is brought, as Mr. Rabin made clear, in the name of the government. And the government is free to release that claim, and that's what it did. It released any claims that exist, whether against telephone companies or telephone customers, who may have paid too few 911 charges in the past. There was no need for them to say any more in order for it to apply to a pending claim. Nor are there any contract rights or vested rights that would require this court to adopt an interpretation of the 2018 law that is contrary to its terms or to hold that it's unconstitutional. So let's start with the contract claim. It wasn't raised below is the first problem. Expert discovery says at page 12 of their reply that they raised a constitutional challenge, and that's true, but not this one. The constitutional challenge that's raised on the pages of the brief that's cited and the transcript that's cited are challenges under Article 1, Sections 18 and 19 of North Carolina's Constitution. There's no mention of the federal Constitution. There's no mention of its contract clause. The word contract doesn't appear in those pages of the brief or transcript or any others. It simply wasn't preserved. But if it had been raised, it would have failed, because False Claims Acts are not unilateral offers by the government to enter into a binding contract with relators of the type that the contract clause protects. We know that for a number of reasons. First, there's the long-standing presumption that statutes don't create contracts, because that would cause one legislature to bind a future legislature. So it is expert discovery's burden to overcome that presumption. And they can't do it because there's no language in the False Claims Act that suggests that the government is entering into a contract with any private relator that happens to file a claim in its name. In fact, the statute reserves the right to the government, it's in section 1-609B, to dismiss the complaint over the objection of the relator, which is an odd contract to think that was being entered into by this statute, where one party reserves the unilateral right to make the other party's effort a nullity. Third, as the Brooks case from the Federal Circuit that we cite makes clear, the history of False Claims Act is that they are not unilateral offers to enter into contracts. And then we have the Dyer case, where the North Carolina Supreme Court says, in the context of a statute that similarly allows a private party to sue for a penalty, that a statute providing a penalty creates no contract between the state and the common informer, even if he acts under the permission given him to sue. And it's telling that expert discovery can't cite a single case from any jurisdiction that has ever found that a False Claims Act is a unilateral offer to enter into a contract of the type the contract clause protects. So the other claim we have is, well, when I filed suit, that is, when expert discovery filed suit, the rights that they got as a plaintiff vested in a way that the legislature cannot interfere with. And that's not the law either. Go back to the Brooks case. In the Brooks case, a plaintiff had filed a False Claims Act suit under the Patent Law's False Claims Act provision. And then Congress got rid of it and said, we don't want this provision to exist anymore. It's going to go away, and we don't want any more cases existing or future under it. And he said, both, I have a contract, they can't do this to me, and the court said no. He said, well, at least I have vested rights, and they can't do this to me. And the court said no as well, relying on a long line of cases under the Federal False Claims Act, and in section 1-616, the North Carolina legislature says its False Claims Act should be interpreted in line with the federal one, said no, as a relator you only have a privilege. Your rights don't vest until judgment. And that's consistent with what Dyer holds as well, that the informer in Dyer, there was no problem taking away its lawsuit because it wouldn't have anything other than inchoate rights until it prevailed. Until then, it had merely these inchoate rights that were subject to destruction by the legislature. And again, I think it's telling that expert discovery can't cite a single case from a single jurisdiction holding that a relator bringing a False Claims Act claim obtains vested rights from the moment it filed that suit. So we have a statute in 2018 that is unambiguously retroactive. It didn't need to say anything more to apply to pending cases to release the government's claims, if any, against telephone companies and telephone customers. We have no contract clause claim. We have no vested rights. The trial court was correct to dismiss the complaint on that ground. There's another ground, too, which is the one Mr. Rabin started with, the first to file bar. And the relevant language there, and it was shown on the screen, it says, and I think it's the right language to focus on, once a complaint has been filed under North Carolina's False Claims Act, the Federal False Claims Act, or any similar provision of law in another state, then no person other than the government, that is the North Carolina Attorney General, may file a related action based on the underlying facts. Now, Mr.
Well, wouldn't North Carolina have to be able to recover under the other act in order for that to bar it under 608?
No, Your Honor, because in fact, what the 608 goes on to say is that the person that filed that first action is allowed to, not obligated to, allowed to amend their complaint if they want to bring the North Carolina False Claims Action claim. But the other point that's important to remember is the first to file bar doesn't apply to the Attorney General. So when the Iowa case came out from under seal and the Attorney General was able to see the allegation in the Iowa complaint, and I think it's telling if we look at that allegation, it's at page 337 of volume 1 of the documentary exhibits, it's paragraph 54. Defendants' conduct, and defendants here is really broad, AT&T, Verizon, CenturyLink, Level 3, WiMAX, Citizens, and their affiliates and related entities are all named, so virtually every defendant in this case is named in that one. Defendants' conduct is not unique with respect to the state of Iowa. Upon information and belief, the defendant's failure to remit 911-related charges and assessments is a pattern and practice of the defendants, and not just them, of the defendants and similar countries throughout the United States. So we have an allegation, and the same one is repeated in the District of Columbia complaint, an allegation that there is this nationwide scheme to violate 911 laws. And that's something that's actually repeated in expert discovery's complaint at page 38 of the record, when they say that the defendants use the same billing practices throughout the United States regardless of the differences in state laws. So the North Carolina complaint is just one particularized instance of this nationwide conspiracy that's been alleged. And when the Iowa complaint comes out from under seal, the North Carolina Attorney General can become aware of it, and the North Carolina Attorney General can file a False Claims Act claim if it wants to, without regard to the pendency of the Iowa action, because the first to file bar doesn't apply to the government. What it does do, though, is it stops a private relator from piggybacking onto that litigation and then claiming for itself the right to take 15 to 25% of the government's damages if it recovers any. So the first to file bar in this way protects the government. If the Iowa complaint actually disclosed, and we obviously take issue with all of the allegations of a nationwide scheme and that we ignore local laws when we develop our systems and bill our customers. We take our obligations very seriously under these laws. But the allegation is out there. The first to file bar means if the government of North Carolina wants to bring a suit, it gets to keep 100% of the damages that it obtained, that nobody else other than that first pending claimant could add North Carolina claims to the complaint. So it's a protection in that way for the government. Now, Mr. Rabin said at length, well, to be an action that can qualify under the first to file bar, the action has to be brought in the name of the state or name the state, but that completely reads out of the first to file bar the rest of the language. Because any action brought in the name of North Carolina under this section would be an action under this subsection. But the statute says that it can also be an action under the Federal False Claims Act, which would be brought in the name of the United States, or under any other similar law in any other state, which would, of course, be brought in the name of those folks. It doesn't say, and North Carolina knows about it, or and North Carolina is also mentioned in the action, because, of course, then the provided clause that says you can amend your complaint to add a claim under our statute wouldn't make any sense. So this is a broad protection that North Carolina had in place for a period of about 10 years, until it was taken out in 2018 to conform to the federal approach. And it is very broad. And we have a case where in Iowa and the District of Columbia, an affiliate, not the same plaintiff, but an affiliate of the current plaintiff, says every telephone company nationwide is doing this. It is a nationwide scheme. These are just, Iowa and DC are just particularized instances in which this is occurring. And that makes it a related case based on substantially the same underlying facts. And that was enough for the trial court to dismiss it on that ground as well. There's a third ground, and I'm going to go back to the 2018 law for a moment. Because in addition to releasing claims against companies and customers for having gotten the old 911 law wrong, the legislature amends the 911 law, and it says, we are now going to tell you with specificity how business customers, those are people who can make more than one call at one time, are supposed to pay 911 charges. And it says they're supposed to pay based on how many calls they can make simultaneously. This is section 37.4A in Session Law 2018-5, and it's at page 76 of the plaintiff's appendix at the bottom of the page. And then in Session Law 2018-97, they say, and this is intended as a clarification of existing law. Now, I know the legislature doesn't get to decide that. That's a job for the court. But the legislature was right. Under the Ray case from the Supreme Court, laws are clarifications when they don't change the substance of the law, but instead just give further insight into the way the legislature intended the law to apply. And that's what this amendment did. It didn't strike out any language of the existing 911 law. It didn't alter any language of the law. It simply explained how to apply the law to a particular set of circumstances. And so under Ray, it's a clarification, but there's extrinsic evidence that it's a clarification that comes from the 911 board. The 911 board creates a form, and it makes every telephone company that remits 911 charges use the form. We provided a picture of it in our brief. It's in the complaint. And that form, before this amendment, said that 911 charges get reported per access line, not per telephone number, as expert discovery alleged that the prior law unambiguously required. The 911 board, charged with running the whole system, making sure that there's enough money in the system to support the needs of the local call answering centers, creates the form per access line. After the 2018 amendment, the form doesn't change. The E911 board does not view this law as a change to the underlying substantive statute. It views it as the same clarification the legislature did. And why is that important? Well, one, Ray says that clarifications apply to pending cases, and there's no need to say, and this applies to pending cases, for a clarification to apply. That's just what clarifications do. Well, if we look at expert discovery's allegations here, all of the False Claims Act allegations depend upon the underlying substantive allegation that we, the telephone companies, violated North Carolina's 911 law. Well, how do they allege that we did that? If we look at Record 68, they allege that the thing we did that was wrong was we billed our customers, we assessed and remitted one 911 charge for the number of calls a customer could place simultaneously. Well, that's what the clarification says we were supposed to have done. So when you combine the clarification with the allegations, what they're alleging is that we did it right. And if we did it right, all of the False Claims Act allegations disappear. We can't have billed correctly, collected correctly, remitted correctly because we did it by how many calls our customers could bill simultaneously, and somehow violated the False Claims Act by doing what we were supposed to have done. All of the false claims allegations, all of the false statement allegations presume that we violated the 911 law because expert discovery presumes that business customers should have paid based on their telephone numbers. Now, why is that important? You probably know this from the court. You can probably call internally using just 4 digits, right? Most businesses have more telephone numbers than they have ability to make outside calls. And that's because not everybody is calling externally or receiving calls at the same time. When you call internally, you don't make use of the external telephone network. It is quite commonplace for businesses to have more phone numbers than they have capability to make calls. And the legislature said, and the 911 board had always said, that that's how you decide how many charges to place, not telephone numbers. And so the premise of the complaint disappears with the 2018 clarification. And at that point, they're no longer alleging a violation of any law, the 911 law or the False Claims Act. And that's an independent basis on which to affirm the judgment. We raised it below. The trial court didn't reach it because Judge Futrell didn't need to reach it, having granted our motion to dismiss under the first-to-file bar, and also because of the release of liability against both telephone companies and telephone customers. If the court has no questions, I know I have some time left, but I think I've covered all the points I wish to.
What is your position on whether or not there is still a claim at the trial court level? Because
There is not, Your Honor. The trial court's April 2021 order resolved all claims against all parties. Had expert discovery both timely filed its appeal and timely served its appeal on all defendants, there'd be no question about this court's appellate jurisdiction or no need for this court to consider exercising its certiorari jurisdiction. We think there was, in fact, a problem with the appellate jurisdiction because a number of us were not timely served and did not get actual notice. We don't think this court should use its certiorari jurisdiction to cure that. But as far as the question of is there anything pending in front of the trial court, no, there's not, Your Honor. If there are no further questions, so I'll see the remainder of my time. Thank you very much.
If I could just make four brief points. First, Mr. Engstreich has referred to the form created by the 911 board, and I would just commend that to the court's consideration. My review is it doesn't say anywhere anything about per access line. That is simply not what the form says, to the extent that's relevant. Regarding the first to file rule, it's simply not a related action based on the same facts to have a complaint filed in Iowa under Iowa's False Claims Act seeking recovery for the state of Iowa. In fact, the defendants have not cited a case anywhere from any court that interprets a first to file rule like this, where there are different state interests involved and one state is left out of the picture. As discussed in the briefs, the first to file rule simply doesn't apply when it's the same plaintiff bringing claims against different defendants under different statutes and different False Claims Act. It's not a related action. And of course, the purpose of the False Claims Act in general is to protect the public fisc, and interpreting the first to file rule in the way the defendants have suggested would be contrary to that purpose. Third, as I understand my friend on the other side's argument, the 2018 legislation is a comprehensive release of everything related to 911 fees. Again, I think looking at the plain language of the 2018 legislation, that's simply not what the legislature said. It's not a broad release, and it's not, certainly not, I heard no argument that the legislation itself applies to pending claims. Nothing in the text of the legislation indicates that it applies to pending claims. As far as the contract and vested rights issue, again, we've cited in the briefs numerous cases from our state Supreme Court that have said statutory penalties do create contracts. And when you've invested time and money and resources into pursuing a penalty, you do have a vested right. So,
Mr. Nelson, could you tell me how the Brooks case, can you distinguish the Brooks case for me?
sure. So Brooks, of course, was a patent case out of the Federal Circuit that was solely a due process challenge to the repeal of a patent qui tam action. And there, the Federal Circuit said you do not have a due process right to pursue this patent qui tam provision. That was the holding. It didn't address an impairment of contracts theory or a vested rights theory. And importantly, to the extent Brooks suggests that there's not a contract, that's contrary to what our state Supreme Court has said under North Carolina law. For example, in Dowdy, the Supreme Court said it is settled law that a statutory penalty in North Carolina creates a contract. So again, Brooks solely dealt with due process, and we've not raised a due process issue here, so Brooks is not persuasive or relevant in that regard, but also to the extent Brooks can be read to suggest that it's no contractual relation is formed, that's contrary to North Carolina precedent. The final point I wanted to make is just taking a step back here in what we're talking about. The purpose of the False Claims Act is to ensure that the money that is supposed to go to the state and the citizens of the state of North Carolina does so. In fact, Section 1-607A4, this is defining a false claim in North Carolina, says it is unlawful for a company like the defendants here to have possession, custody, or control of property or money used or to be used by the state, and when they knowingly deliver or cause to be delivered less than all of that money or property. That's what's been alleged here, that hundreds of millions of dollars were withheld from the 911 fund that should have gone to the benefit of the states. To the extent the defendants want to argue why they shouldn't be held liable or why they think they complied with the statute, those are merits questions that need to be decided. And if they can prove to a fact finder that they haven't cheated the state out of money, then so be it. But the claim should be allowed to proceed. And for those reasons, we would ask that you reverse.
The appellee made reference to the fact that you failed to preserve the contract constitutional issue. You want to talk about that for a second before you...
Sure, if I may. So Mr. Angstreich is correct that the word contract was not raised. I think there are two important points here. First, this was not a constitutional challenge to the legislation. We asserted claims, the defendants asserted the 2018 legislation as a defense to those claims, and in response, expert discovery said there are constitutional implications if you do that. So that's, if you look at pages 430 to 35 of the documentary exhibits and in the transcript, those were the constitutional concerns that were raised. But also, the cases that were cited by expert discovery, they often conflate the impairments of contract and vested rights theory. So although the word contract was not used, the authorities cited did rely on both a contract and vested right theory. So as most recently explained by our Supreme Court in MEVTJ, raising that sort of constitutional challenge is sufficient to preserve it.
Thank you.
Thank you.
Thank you, counsel, for excellent arguments.
All rise.